Well, thank you, Thomas. Chief Justice, fellow contributors, ladies and gentlemen. I couldn't help reflecting as I looked around the courtroom that among the portraits of former Chief Justices of this court, there are three former members of the Queensland Parliament: Sir Charles Wonstall, who served in the 1940s, Sir Charles Lilly, and Sir Samuel Griffith, who served in the 19th century, and one unsuccessful aspirant to join the Queensland Parliament, Sir Walter Campbell, who sought but failed to be elected, or pre-selected indeed, at the 1957 election. That reflection reminds me of two things. First of all, that there are occasions, and the debate about the Bill of Rights is one of them, where political affairs and matters that concern lawyers come into very close proximity with each other. But more importantly, it reminded me that what Sir Charles Wonstall and Sir Charles Lilly and Sir Samuel Griffith all had in common was when they left Parliament and became members of the judiciary, they left politics behind them. No doubt they continued privately to hold their political opinions, but they understood that the role of the legislature and the role of the judiciary were entirely separate. I don't want to take up your time preaching to an audience of people who I dare say are largely converted to this cause, but the one point I'd like to make in my remarks is this: that whatever else it may be, the case for an Australian Bill of Rights is an assault on the separation of powers, more profound than anything we have yet seen in this country. It is, in a sense, a great compliment to the integrity and skill of Australia's judges that the proponents of the Bill of Rights maintain that all we have to do to have a controversy about human rights resolved with pure skill and almost platonic wisdom is to send it to the courts, so that judges, rather than people elected to Parliament, will deliberate and adjudicate on these matters. I can't help thinking that if members of the judiciary, with all due respect to current and former members of the judiciary, were subjected to the same daily scrutiny in their working lives as members of Parliament, perhaps the public view of the judiciary might not be as perfect as it is. But nevertheless, it is a great tribute to the reputation of the Australian judiciary. There is no surer way to compromise that reputation than to have judges deciding political questions. And by political questions, I don't mean the sort of questions that inevitably arise in ordinary constitutional adjudication. I mean the sorts of policy questions to which David Bennett has referred. So those of us who make the argument against a Bill of Rights on many, many grounds concentrate largely on the importance of maintaining the separation of powers, ensuring that those who make decisions about public values are accountable through a robust and unforgiving democratic process, and those who adjudicate society's disputes in relation to the application of laws to particular cases are equally and conversely immune, as they ought to be, from democratic pressures. Introduce a Bill of Rights, and what you will do in Australia is to politicise the judiciary and to trivialise the Parliament. It is a profound attack on the separation of powers, as I think increasingly those who participate in this debate are coming to realise, hence the hesitancy that is increasingly evident from the Brennan Committee, whose report we await. I want to thank the Chief Justice for the hospitality of the court in this important occasion. I want to congratulate the Menzies Research Centre and in particular Julian Lisa and Ryan Hadrick for putting this very significant volume together, and to remind you all the etiquette for those invited to the launch of the book is to buy a copy. Thank you.